The law on sales, Articles 1509 to 1512, as presented by Group 2. Before we begin with the articles, let us first find out what a document of title is. A document of title is a document used in the ordinary course of business in the sale or transfer of goods as proof of possession or control of the goods, or authorizing or purporting to authorize the holder of the document to transfer the goods represented by the document or receive them by either declivity or endorsement. The following are examples of documents of title. You have a kedan, a bill of lading, warehouse receipt, and a dock warrant. If you may ask, what are the functions of a negotiable document of title? First, it is a contract. Second, it is an evidence of receipt of goods. And third, they represent the goods or control over the goods. Then you might ask, what is a negotiable document of title? A document of title is negotiable if it states that the goods indicated on it will be delivered to the bearer, or the order of the person named in the document. Now let's proceed to Article 1509, which is all about negotiation of negotiable document of title by endorsement. It states that a negotiable document of title may be negotiated by the endorsement of the person to whose order the goods are by the terms of document deliverable. Such endorsement may be in blank, to bearer or to a specified person. If endorsed to a specified person, it may be again negotiated by the endorsement of such person in blank, to bearer or to another specified person. Subsequent negotiations may be made in like manner. Always remember, as a general rule, a negotiable document of title by the terms of which the goods are deliverable to a person specified therein may be negotiated only by the endorsement of such person. And the rules are as follows. Number 1, if endorsed in blank or to bearer, the document becomes negotiable by delivery. And number 2, if endorsed to a specified person, it may be again negotiated by the endorsement of such person in blank, to bearer or to another specified person. Keep in mind, delivery alone is not sufficient. When a document of title passes, always remember too that a party is liable only as guarantor and not as endorser if his endorsement is made for the purpose of identification only. Keep in mind, these are important in the intent to transfer the title. First, the title will pass only if the seller intends it shall and the buyer agrees to accept it. Number 2, while title will not pass unless there is an intention to pass it, if the negotiable document of title is delivered by the owner or by the person appearing to be the owner after endorsement in blank without more or unless explained, implies an intent to transfer the title. Again, endorsement and delivery of such documents is commonly understood by merchants as importing a transfer of title. Article 1510 on negotiable documents of title marked non-negotiable. It states that if a document of title which contains an undertaking by a carrier, warehouseman, or other bailee to deliver the goods to bearer to a specified person or order of a specified person, or which contains words of, like import, has placed upon it the words not negotiable, non-negotiable, or the like, such document may nevertheless be negotiated by the holder and is a negotiable document of title within the meaning of this title. But nothing in this title contained shall be construed as limiting or defining the effect upon the obligations of the carrier, warehouseman, or other bailee, issuing a document of title or placing thereon the words not negotiable, non-negotiable, or the like. So what are the effects when document of title is marked non-negotiable? Well, it has no effect, and the document continues to be negotiable, as in the case of Roman versus Asia Banking Corporation. It is also important to remember that under the warehouse receipts law, any provision inserted in a negotiable receipt that is non-negotiable is void. And when the document of title is to order, the bailee is obliged to take it up before delivering the goods. Accordingly, he is liable to the holder of an order document if the goods are delivered to the consignee without surrender of the document, even though the latter was marked non-negotiable. Article 1511 pertains to the transfer of non-negotiable documents, and it states, a document of title which is not in such form that it can be negotiated by delivery may be transferred by the holder by delivery to a purchaser or donee. A non-negotiable document cannot be negotiated, and the endorsement of such a document receives the transferee no additional right. Let us differentiate negotiation from transfer. Negotiation is used with respect to documents negotiable in form, whereas transfer is used with respect to non-negotiable documents. Rules on transfers and its application. Number 1. The transfer of documents originally made out of order but not properly endorsed for negotiation at the time of the transfer. The document itself is the symbol of the goods, but under the terms of the document, the new holder does not become the promisee of the bailee. Since the holder is not the order of the person to whom the document was originally made, he is not entitled to enforce bailee's promise. Number 2. The transfer of straight BOL and similar documents in which the bailee's promise is merely to a specific person. The document is not properly the symbol of the goods. In practice, a carrier may deliver goods billed straight without demanding from the consignee the surrender of the BOL. Thus, a straight BOL or a similar document cannot be said to be the symbol of the goods, as the document itself is not necessary for acquiring possession of the goods. To reiterate, the transfer of non-negotiable documents as pertained to in Article 1511, a non-negotiable document of title cannot be negotiated. Nevertheless, it can be transferred or assigned by delivery. The transferee or assignee acquires only the rights stated in Article 1514. Even if the document is endorsed, the transferee acquires no additional right. Article 1512 refers to persons who may negotiate a document. A negotiable document of title may be negotiated by, number 1, the owner thereof, or number 2, by any person to whom the possession or custody of the document has been entrusted by the owner. If, by the terms of the document, the bailee issuing the document undertakes to deliver the goods to the order of the person to whom the possession or custody of the document has been entrusted, or if at the time of such entrusting the document is in such form that it may be negotiated by delivery. Persons who may negotiate a document. Number 1, the owner thereof. Number 2, any person to whom the possession or custody of the document has been entrusted by the owner. Please take note that this article is similar to Section 40 of the Warehouse Receipts Law. However, if the owner of the goods permits another to have the possession or custody of negotiable receipts running to the order of the latter or to bearer, it is a representation of title, upon which bona fide purchasers for virtue are entitled to rely, despite breaches of trust or violations of agreement on the part of the apparent owner. As between two innocent persons, the loss must fall upon him whose misplaced confidence made the loss possible. This is the case of C. Kong Bien and Company. This has been Group 2 composed. This has been Group 2 of Sales. Thank you for listening.